Okay, so I'm going to give an update on what happened this morning. I'm going to start at the end and kind of let you know what was put on the record at the very end. It was put on the record by Rasmussen that Pete is not testifying against other defendants in this trial, and that he is not handing over his works against the other defendants in this trial. There was some confusion. They are requiring that Pete hand over his original discovery. I believe it's so that he cannot release discovery because discovery is still protected. This does not include anything that he works. They did say, in fact, that it is the original discovery, the original thing that the government gave to each of the guys. So it has none of his works, and his lawyer said that he has all the works, and that will not go to the prosecution. So we're going to go right to the beginning. They ask a lot of questions to Pete, making sure that he wasn't coerced into this. The terms are non-binding. He's waiving his trial rights. He cannot withdraw his plea if the if the judge doesn't go with the suggestions. And she did go in length talking about how it's not binding. She does not have to go with the suggestions. His sentencing guidelines were a base level of 10 plus 6 levels because of the, what did it say? Something about the victims, and plus 5 levels for something else, and goes to 21, minus 2 for accepting the plea, and a 4-level reduction for timely resolution, leaving it with 15. He said they don't know about the criminal history, so it could go up after pretrial does its pretrial sentencing, whatever. They agreed to recommend time served. Once again, this is a recommendation. Let's see. Sorry, I'm trying to hold this and do it at the same time. They're not asking for any forfeiture. They are both agreeing that the defendant could be released pre-trial. He is not allowed to be speaking with any defendants or witnesses, anything like that. They talked about the fact that he's taking a felony. The max sentence is 6 years with $250,000 restitution. They said they're not asking for restitution, but once again, the judge is not binded by any of this. They did say $100 per count will be due at the time of sentencing. And she is not required, once again, she's not required to go with the suggestions. Parole has been abolished in the federal system, so they are, there's the thing called supervised release, not to exceed 3 years. That's after his time, so he could be given more time, and then 3 years supervised release. Then she goes in extensively to talk about supervised release, saying that if you do great in your first year, but then you mess up, you could be then put back into prison for the whole 3 years, and that your prison time could be longer than your actual, mandatory time or the top level of time. So they're saying here that, 6 years is the maximum, but if you're given 6 years and then 3 years pre-trial, or supervised release, and then you mess up at those supervised release, you can then be additionally given 3 years because you messed up on your release and actually serve 9 years. So then we go into the guilty plea facts. On March 28th, the BLM feds were exacting a court order. He knew Cliven and Sons planned to impede or interfere with that court order. Santilli used force to impede by using his car to block the convoy path. That he was ordered to move his vehicle and did not until, and then in the courtroom they actually said until a BLM officer forcefully started to move the car with his car. That was then said, no, that wasn't part of it. They took that part out. So it was reread without the vehicle. He did not move it until asked several times, and then he moved his vehicle. By using force to block the convoy, he allowed other defendants to surround the convoy and threaten federal officers with force. And then the court accepted his guilty plea. Then they talk about the pre-sentence report and the fact that he has to really pay attention to that because it's not just used for the sentencing. IRS can also use it. Homeland Security can also use it. His sentencing is scheduled for Thursday, January 11th, 2018 at 8 a.m. Something about no forfeiture. They're not asking for forfeiture. Something about a money order, but that was figured out, or they agreed to something. They talked about all of his motions that they're taking back. Most of them were joinders, except for 2552. Exclude references to Oregon trial. So it looks like that's the only one that somebody has to file again if they want that put in for them as well. They motioned for a release and would like to be returned to Cincinnati. The release conditions, and they pretty much took the Oregon release conditions and read that. So he has to go through a mental health evaluation. Travel will be limited to the District of Nevada and the Southern District of Ohio. No weapons in the house. Submit to search. Then they started to do monitoring, and he was going to be on a monitoring device. He was going to have to pay for that. They wouldn't be allowed to do anything. He has to get a job right away, a full-time job. He talked about how he's a disabled veteran, and that might be a difficulty. They have to talk about that with pretrial release. He's not committed a new crime, but they will not stop him from broadcasting anything. His lawyer then gets up and says, Mr. Santilli will not broadcast anything to do with the Bundy trials, or this trial, he said, or the patriot community. So this is I believe, part of the pretrial stipulations. But his lawyer got up and talked about that. Then let's see. If he violates anything, the pretrial services will alert the law enforcement officers. Then, once again, I'm going to end with what they ended with in the courtroom. I started with this. Mr. Santilli is not testifying and will not turn over work products, only the raw discovery. Once again, that is because the raw discovery is protected. And it's only what was given to him in the beginning, the raw product, nothing that's been worked on. He has only had one subpoena entered for Marty Martinez, so one of the other lawyers might possibly have to do that. He will not directly or indirectly break the protective order to not release the information. That's the discovery. And that's all I have. We're going back inside for the other hearing, where we will find out if Eric's lawyer is allowed to quit.